The resolution of necessity process really has nothing to do with the determination of compensation.
It's a starting line.
It's a starting point.
Thank you.
Okay, no more questions? Would anybody like to make a motion?
Madam Mayor, if I may, this is a public hearing, and I
Oh, so
believe...
we will open the public hearing.
Yes, ma'am.
And we do actually have one request to speak on this, and that is from Paul Perazzo.
Madam Mayor, honorable members of the Folsom City Council and guests, greetings. My name is Paul Perazzo and I represent the Perazzo family. Thank you for your time and your attention allowing us to present our view of the ownership and history regarding the proposed eminent domain of the parcel on East Bidwell Street listed as 072-001-022-00000, Exhibit A. Amounting to less than 1 acre, this Folsom triangle has turned it into a similar amount of trouble for us. We are in agreement of the proposed improvements. They are long overdue. This is the only gap in the sidewalk of Folsom. Our apologies, as we would have sold the easement gladly and much earlier if we were the sole owners. We are not the sole owners if indeed we are the owners at all. There is a list of 5 principals and 7 charities derived from the will of the late Charles Anderson. Exhibit B. Mr. Anderson was the late husband of the late Alice Grace Weil Perazzo Anderson, our great-great-grandmother. Exhibit C. That listed agreement with our understanding, as well as the finding of the Sacramento County's assessors and the tax collection arm of the Director of Financing in 2005, who, after researching for escape back taxes on this parcel, forwarded their finders with a bill to us by certified letter. It was somewhat of a surprise to find we still had ownership of a piece of the vast Perazzo land holdings from the estates of Joe and Peter Perazzo via their descendants and assigns. Their acquired lands totaled over 2,000 acres, shown on the map generated by the California State Land Surveyor J.C. Boyd in March of 1898, Exhibit D. Although this map does not show the parcel in question, it's proof positive that it was owned by the Perazzo brothers. It seems doubtful that of all the land shown, the parcel in question would escape their possession soon or sometime after that date. We are certain that it is recorded elsewhere. We believe our ownership has validity. In the meantime, because of economics, we could not pursue legal actions to perfect that claim, but we were the sole respondent to the tax liability, the only one. Where were the other so-called owners? More recently, after many conversations with Interwest Consulting, was culminated in more or less a stalemate. The matter reverted back to legal for a decision. The request for more information resulted in a totally new and obscure owner from a deed inferred by the title record search of July 2017 by Fidelity National Title, finding instead for the Wilkes-Barre Dredging Company from 1917, Exhibit E. In the report, which was contracted by Interwest Consulting, the deed record was not specified, only that it exempts that certain grant deed to J.P. Cox recorded June 12, 1917 in book 470, page 145. Attached to the end of that particular deed is a map of the Wilkes-Barre Dredging Company holdings, Exhibit F. That map was compared to the surviving map of the Perazzo brothers' holdings, and the retracement of the deed description seems to be curiously matched lands held by the Perazzo brothers in 1898. In fact, it is nearly identical, Exhibit G. That coincidental agreement matches other information concerning the dredging history in the Sacramento County, particularly in the Folsom area. The original dredging company seems to be the Union, which was purchased by a Mr. Kirby for Wilkes-Barre, which in turn was bought by J.P. Cox. It is unclear how the Natomas Company acquired any holdings from Wilkes-Barre, if any. This is attested by available deed records and several historical journals. Exhibit H. Regardless, the parcel in question is still notoriously absent from either plat or map. The old saying, "You can't sell what you don't own," does not apply to the government. Eminent domain is the tool to acquire land the government doesn't own. Clear title is necessary, but without it, eminent domain is not needed. It seems to be the case in point. If fidelity is correct, if we don't own the parcel, or at least 11.3% more or less, then we've redeemed the delinquent tax liability in vain. However, others are guilty of this also. Mr. Anderson, in good faith, transferred his ownership to the heirs and assigns, but where did he get the idea that he owned it? His marriage to Alice gave him the right. Did Alice own it? How? From her husband, Joe Perazzo. Mrs. McDonald, on the list from Mr. Anderson, also quitclaimed in good faith to Mr. Avila when notified of the liability in 2006. Mrs. Perazzo had several legal hopes to jump through, first establishing Mr. Perazzo as legal heir, then to her interests, then to her heirs and assigns, her children. This chain of title is more recent. Joe died in 33, Alice in 62, Charlie in 71, LV in 87, same as Mr. Perazzo, and Mrs. Perazzo died in 2000. Mr. Perazzo and Mrs. Perazzo died in 2010. Mrs. McDonald seems to have transferred her interest in September of 2006, soon after the delinquent tax notice. All this is in vain in the finding of fidelity. National title is correct. There is another saying, paying taxes doesn't make you an owner. But good faith efforts like paying taxes at least makes the claim of ownership more believable. The only exception is in the claims of adverse possession. That takes 7 to 10 years. Let's see, 2006, 2016. In short, everything is needed for a favorable resolution to this problem is either buried in records, obliterated by time, and or complicated by human endeavors. I don't wish to belabor the facts presented here or cast a poor light on anyone involved that has or may disagree with our position. I only meant to present what we believe to be admittedly a relatively weak ownership claim based on money spent and efforts in good faith to ascertain the truth of the matter before you today. If you believe we have a claim of ownership, purchase the improvement easement premise, let us haggle with the other so-called owners. That's not that much more trouble. There's more that could be presented this time. We're available afterwards for any comments or questions. Thank you again for your time and your consideration.
Thank you, that's all very, very interesting information, but there's not a damn thing we can do with it. So, I wish you and your family well in the court proceedings.
Thank you very much.
It's a good mystery to tell your grandkids. So do we have anybody else that would like to speak to this? Then I will close the public hearing and entertain a motion.
I'll make a motion that we approve resolution number 10244 and resolution 10245.
Do we need to do that one at a time?
Separately, please.
Separately?
Thank you.
Well, then I will move 10244 as presented.
We have a motion, do we have a second?
I'll second.
Any further questions
Just to
on?
be clear, that's the Bridges property, correct?
Yes.
That is correct.
Clerk will call the roll, please.
Councilmember Sheldon?
Yes.
Aquino?
Yes.
Gaylord?
No.
Kozlowski?
Yes.
And Howell?
Yes. Do we have a resolution, a motion for resolution 10245?
All motion 10245.
Second. We have a motion and a second. Call the roll, please.
Councilmember Sheldon?
Yes.
Aquino?
Yes.
Gaylord?
Yes.
Kozlowski?
Yes.
And Howell?
Yes.
Thank you, Madam Mayor and members of City Council. Allow me to transition to the esteemed Jim Francis.